So it was in the news this week that Miramax has sued Quentin Tarantino over something to do with NFTs being offered with Pulp Fiction intellectual property. So let's take a look at what's going on here. Miramax filed a complaint for breach of contract, copyright infringement, trademark infringement, and unfair competition. And let's just jump right into the interesting parts. Eager to cash in on the non-fungible token boom. As widely reported in the media, Quentin Tarantino recently announced plans to auction off 7 exclusive scenes from the 1994 motion picture Pulp Fiction in the form of NFTs. According to the official website for the sale, TarantinoNFTs.com, which looks like this, and we'll check it out in a moment. The collection holds secrets from Pulp Fiction, and each NFT contains one or more previously unknown secrets of a specific iconic scene from Pulp Fiction. The privileged purchasers will get a hold of these secrets. Tarantino kept this Pulp Fiction NFT plan secret from Miramax, his longtime financier and collaborator on multiple critically and commercially successful films, including Pulp Fiction, Jackie Brown, and Kill Bill Volumes 1 and 2. He made no efforts to contact Miramax prior to his coordinated press campaign, despite having what were likely extensive negotiations with third parties to develop and sell NFTs. So far, this is really going to come down to whether he had the right to do so. When you have these agreements, the writer or director, they're going to have some intellectual property that they hold and other intellectual property that is the exclusive property or is in the exclusive control of the publisher or studio. So that's what we're going to be looking for here. The fact that Tarantino kept Miramax out of the loop is problematic because he granted and assigned nearly all of his rights to Pulp Fiction and its elements in all stages of development and production to Miramax in 1993, including the rights necessary for the secrets from Pulp Fiction that he intends to sell. Tarantino's limited reserved rights under the operative agreements are far too narrow for him to unilaterally produce, market, and sell the Pulp Fiction NFTs. Upon learning of Tarantino's plan, Miramax sent him a cease and desist letter setting forth in great detail Tarantino's disregard of Miramax's broad rights to Pulp Fiction, wrongly claiming that his narrow reserved rights are sufficient. Tarantino remains undeterred and has refused to comply with Miramax's demands to cancel the sale of Pulp Fiction NFTs. Definitely make sure you watch to the end of this one to see the final understanding of this dispute. Days after being told to cease and desist, Tarantino's initial plans to sell NFTs relating to Miramax's intellectual property intensified and expanded. According to a promotional Twitter account for the sale, @TarantinoNFTs, the Pulp Fiction NFTs, which will include scans of some pages of the script, will be sold in December 2021, and Tarantino will also sell the Artifacts collection of up to 10 iconic props from Tarantino's films, including one from Pulp Fiction. The account is using an animated scene from another Miramax film, Kill Bill Volume 2, as well as unauthorized images and graphics from or relating to Pulp Fiction to promote the sale. Tarantino's conduct has forced Miramax to bring this lawsuit against a valued collaborator in order to enforce, preserve, and protect its contractual and intellectual property rights relating to one of Miramax's most iconic and valuable film properties. Left unchecked, Tarantino's conduct could mislead others into believing Miramax is involved in his venture, and it could also mislead others into believing they have the rights to pursue similar deals or offerings, when in fact Miramax holds the rights needed to develop, market, and sell NFTs relating to its deep film library. And that last part should give us kind of an insight as to why they're doing this now. They could also wait and see what happens with the sale of the NFTs and what is actually released and sold. They think they know that it's going to include intellectual property that he doesn't have rights to, and I guess they're afraid that this is the slippery slope that will lead to others doing the same thing, and the dilution of Miramax trademarks and intellectual property and the loss of Miramax revenue, I guess. Let's continue. Pulp Fiction was written and directed by Quentin Tarantino and produced by Lawrence Bender in collaboration with Brown 25 Productions. Effective as of June 23, 1993, Tarantino and Bender entered into an agreement, the original rights agreement with Miramax Film Corp., predecessor in interest to Miramax, relating to the production and financing of Pulp Fiction and the acquisition by Miramax of the film. Under the original rights agreement, Tarantino and Bender granted to Miramax, in exchange for valuable consideration, which I'm assuming is pay, in perpetuity throughout the universe, all rights, including copyrights and trademarks, in and to the film, and all elements thereof in all stages of development and production, now or hereafter known, including without limitation the right to distribute the film in all media, now or hereafter known, theatrical, non-theatrical, all forms of television, home video, etc. I would like to see Pulp Fiction the musical, excluding only a limited set of reserved rights which were reserved to Tarantino as an individual. Tarantino's reserved rights. This is the really important part. Tarantino's reserved rights were limited to the soundtrack album, music publishing, live performance, print publication, including without limitation screenplay publication, making of books, comic books and novelization in audio and electronic formats, as applicable, interactive media, theatrical and television sequel and remake rights, and television series and spin-off rights. Those reserved rights were subject to further restrictions set forth elsewhere, including Miramax's right of first negotiation and last matching rights with respect to certain deals, which rights include all rights now or hereafter known in all media now or hereafter known, Tarantino's reserved rights, which are a narrowly drafted static exception to Miramax's broad catch-all rights, do not contain any forward-looking language. Tarantino's reserved rights do not encompass any rights or media that were not known at the time of the original rights agreement. I'm starting to get the picture here. So they're going to say that NFTs weren't a thing back then. So because NFTs are a new media, that they get the right to NFTs. I don't think so. I think NFTs are akin to a title, as in a title of ownership, a certificate that shows who owns something, and not... Hear me out here, and please correct me if I'm wrong, because I'm still a little fuzzy on exactly what NFTs cover, but the NFT is like the title to the car. It's not the car, but it can have the digital version of the car in it, I think. But I'm guessing that what we're talking about here is more so an NFT that contains the ownership record in a blockchain, and then the actual content is either pointed to, I guess there's nothing stopping it from being contained in the blockchain or the NFT. So somebody tell me what that's all about. NFT is a certificate of ownership, for example, of a JPEG file. That's my impression of it. Tarantino's infringing conduct. The Secret Network, on November 2nd, 2021, Secret Network Labs issued a press release announcing that Tarantino will auction off 7 uncut Pulp Fiction scenes as secret NFTs. An NFT is a unique, non-fungible digital asset recorded on a blockchain, a ledger, that can, as in the case of Pulp Fiction, NFTs represent and certify its owner's right to, and enable its owner to, access specific digital content associated with the NFT. Despite the sweeping rights granted to Miramax, etc., Tarantino did not consult with Miramax. Yes, we get it. Miramax is very upset that they were not consulted. The press release also noted that the initial auctions would occur on OpenSea, the world's largest NFT marketplace, and described the Pulp Fiction NFTs as containing one-of-a-kind content that has never been seen or heard before, including the uncut first handwritten scripts of Pulp Fiction and exclusive custom commentary from Tarantino revealing secrets about the film and its creator. Okay, let's go back to those reserved rights and see, is he allowed to publish or transfer the first uncut handwritten scripts of Pulp Fiction and custom commentary from Tarantino? Tarantino's reserved rights are the soundtrack album, music publishing, live performance, print publication, interactive media, theatrical and television sequel and remake rights, and television and spin-off rights. Does have the right to screenplay publication. Screenplay publication would seem to me to be the script that is the screenplay. Maybe there's a distinction here that makes a difference, but so far it looks like if he has the right to do making of content and screenplay publication, then that means he's allowed to publish the script. What am I missing here? Somebody point this out to me. Maybe we have to continue. According to the press release, even the public metadata of the NFT, the front cover of this exclusive content, is rare in its own right. In other words, each of the 7 Pulp Fiction NFTs would be a unique, never-before public-facing work of art. Tarantino publicly expressed his excitement around the Pulp Fiction NFTs. I mean, hell, I'm getting excited about it. And was quoted, excited to be presenting these exclusive scenes from Pulp Fiction to fans. He also purportedly announced Pulp Fiction NFTs at the NFT.NYC Crypto Art Conference. The substance of the press release were widely reported to the media. In collaboration, Tarantino established a website promoting the Pulp Fiction NFTs. Let's take a look at that now. This is the website. The NFT contains the handwritten, never-before-seen screenplay of Pulp Fiction, one of the most influencing artworks of modern film. Each NFT consists of a single iconic scene, so it's not like he's publishing the film, he's publishing the script, including personalized audio commentary from Quentin Tarantino. That seems well within the reserved rights, the behind-the-scenes commentary. The collector who will purchase one of these few and rare NFTs will get a hold of secrets from the screenplay and a glimpse into the mind and the creative process of Quentin Tarantino. The owner will enjoy the freedom of choosing between 1. Keeping the secrets to himself for all eternity, 2. Sharing the secrets with a few trusted loved ones, or 3. Sharing the secrets publicly with the world. I mean, facts aren't copyrightable. There doesn't seem to be like a non-disclosure agreement or confidentiality agreement here. Maybe there could be a violation of some agreement not to transfer rights away. Maybe he can't transfer the rights away, but it seems like it's well within his reserved rights to do whatever he wants with those things that we read. The promotional website prominently uses the film's name, Pulp Fiction, and uses unauthorized images of Vincent and Jules and Mia Wallace. According to the website, the collection holds secrets. Yeah, we read all of that. In short, defendants seek to capitalize unilaterally on Miramax's rights to Pulp Fiction. I don't really see that. I mean, they said these are from Pulp Fiction, but we do have something in trademark law called fair use, which allows you to refer to things factually, referencing a trademark to identify the goods and services that the trademark holder identifies with the mark. So saying it is an NFT of Pulp Fiction content is a fair use by name. You are naming it, therefore it is nominative fair use. You can also make a descriptive fair use. Saying that something is honeycomb shaped, for example, does not infringe on a trademark for honeycomb dehumidifiers. So somebody else could make a humidifier that has honeycomb shape to it. There may be trade dress problems or something. I mean, honeycomb is literally the shape of the elderwood box that we're currently litigating over. So there is something in the law for trademark fair use. So saying that we're releasing an NFT of the screenplay that is Tarantino's screenplay and behind-the-scenes commentary, that doesn't seem to be infringing on Miramax's trademark. You're not telling people this is endorsed by Miramax. You're not saying it's endorsed by Pulp Fiction. And let's be clear here, Pulp Fiction isn't really a source identifier. Trademarks are supposed to be source identifiers. When I go to a store and I buy Coca-Cola, I know that it comes from the Coca-Cola company and it has a certain amount of quality. When I go to buy a t-shirt, for example, the name on the tag is the source of the product, not the contents of the front of the shirt. And that was the subject of a trademark lawsuit that was lost a few years ago, and I'll try to remember. I think it was Turn Up the Beat, or Let Us Turn Up the Beat, was, I think, one of the lawsuits about that. So this, I think, falls into the nominative fair use situation. And unless the content of the NFTs actually goes outside Tarantino's reserved rights, I think Tarantino's got this one in the NFT, if that translates. Defendants' infringing acts have caused and are likely to cause confusion, mistakes, and deception among the relevant consuming public as to the source of the NFTs, and have deceived or are likely to deceive the relevant consuming public into believing mistakenly that Pulp Fiction NFTs originate from Miramax. I don't see it, but sure, we could disagree and have a reasonable debate in the comments. Go for it. Tarantino refuses to stop the unlawful conduct. Miramax sent a cease and desist and explained that they own all versions of the screenplay, including all scenes and elements thereof. Wait a second. I literally just got done saying that they didn't have the reserved rights. And his reserved rights are to screenplay publication. So what the heck is going on here? Well, they say that they own the screenplay, including all scenes regardless of whether they were filmed or incorporated into the film. This is going to be a point of contention. Both sides are going to have to show who the heck owns the screenplay or script, because it sounds to me like the reserved rights gives Tarantino the screenplay rights. And now, literally like one sentence later, Miramax's rights, subject to Tarantino's rights, are the screenplay. What am I missing? Someone please tell me what I'm missing. The cease and desist letter also put Tarantino on notice that his purported licensing of the rights to develop and sell NFTs from Pulp Fiction constitutes a material breach of the agreement. Miramax demanded that he discontinue these efforts and withdraw from any agreements and issue a public statement that the sale is canceled. They also demanded that he provide a copy of these agreements. Tarantino's counsel emailed Miramax confirming several statements from the press release, namely that the Pulp Fiction NFTs would be a collection of 7 NFTs, each containing a high-resolution digital scan of Quentin's original handwritten screenplay pages for a single scene from his screenplay for Pulp Fiction. There would be no other embellishment or additions to the actual screenplay scans themselves. Each NFT will include a drawing that will be inspired by some element from the scene. Tarantino's counsel has contended that Tarantino was acting within his reserved rights, specifically the right to screenplay publication, which is written in the definition of Tarantino's reserved rights as a subset of his print publication reserved right. Okay, so maybe that's what they're saying. Maybe they're saying that he only has the right to print publication, as in it can't be a digital NFT? I don't know. These are starting to be real minutia here. The proposed sale of a few original script pages or scenes as an NFT is a one-time transaction which does not constitute publication and in any event does not fall within the intended meaning of print publication or screenplay publication. Really? Really? The right to sell NFTs of such excerpts of any version of the screenplay of Pulp Fiction is owned and controlled by Miramax. There it is. They think that he can't publish the screenplay because it's not in print format, and that all other rights fall to Miramax. I don't entirely read it that way, but they probably know their agreements better than I do. But I'm skeptical. Let's put it that way. I'm skeptical. Days after being told to cease and desist, Tarantino's plans to sell NFTs intensified and expanded. The Twitter account announced, with unauthorized images of characters from Pulp Fiction, that the Pulp Fiction NFTs will be sold in December, and that Tarantino will also sell the Artifacts collection of up to 10 iconic props from Tarantino's films, including one from Pulp Fiction. In a tweet claiming that the Artifacts collection is curated and directed by Tarantino, the account uses an animated scene from a different Miramax film, Kill Bill Volume 2, depicting the character Pai Mei, played by Gordon Liu. I want to top expectations. I want to blow you away. Consider that the artifacts collection is curated and directed by the man himself. Get ready to have your mind blown, I think is the emoji there. In another tweet, Tarantino NFTs promotes the sale of the Royale with Cheese scene using a fake Pulp Fiction VHS tape with unauthorized imagery from the film as seen here. I don't know how that's unauthorized imagery from the film, because why would the film have a VHS tape of the film's name on it in the film? I don't get that one. As of the date of filing the complaint, the media continues to report of the impending release of the NFTs. Tarantino's counsel has not complied with the cease and desist letter's demands, necessitating the filing of this lawsuit. Tarantino's conduct may mislead other creators into believing they have rights to exploit Miramax films through NFTs. That's mere speculation. I don't think that has any bearing on the lawsuit, but sure, they're motivated because they think it's going to be a slippery slope. So they claim breach of contract. Let me see if there's anything in here. Original rights agreement, plus all the other agreements, claim that they own, Miramax owns all rights, including copyrights and trademarks, in and to the film, all elements thereof, all stages of production and development, now or hereafter known, without limitation, except of course it is with limitation. They have the Tarantino reserved rights. It says here, yes, without, I love this. It says without limitation, but then excluding a limited set of reserved rights. I know. The without limitation probably applies to the right to distribute the film in all media, now or hereafter known. But I don't think that the NFT constitutes new media for distribution of the film when we're talking about his screenplay publication. Let me go look one more time. So they're saying that print publication includes the screenplay publication, that the screenplay can only be put to print and sold in print, not in an NFT. I think that's the crux of this lawsuit. I think that's really splitting hairs, but I don't know. They are so upset that he didn't work with them on this and include them in this that they have filed a federal lawsuit over it. Those grants and assignments prohibit defendants from exploiting or licensing those same rights to develop and sell Pulp Fiction NFTs. Miramax has been damaged, will continue to be damaged. Okay, copyright infringement. Defendant's sale of rights relating to Pulp. I don't know if he's selling rights. I think he's selling the NFT, but I'm not sure that it's a transfer of rights. So they're claiming that they have the right to the recovery of profits attributable to the infringing conduct, etc. Standard stuff for copyright. Trademark infringement because he used the Pulp Fiction mark. That's going to be fought, I think, on the nominative fair use grounds. Fourth claim is unfair competition under 15 USC, which would be trademark as well, that it deceives consumers as to the origin of goods. And they ask for damages and declaratory relief and injunctive relief, preventing further violations, attorney's fees, costs, and other relief. So that's super interesting. Let me take a look at the docket and see if they've moved for a preliminary injunction or temporary restraining order. Complaint, a bunch of stuff, summons, proof of service. So Tarantino was served on November 19th. Assuming that that is direct service and not a waiver of service, we have the 28th, the 26th, the 3rd, and he would have to answer by December 10th. If anybody wants to look at this, you just go to Court Listener /recap, the recap archive here, and you would just search for Miramax v. Tarantino, or just Miramax and Tarantino, because Court Listener's search engine will include the V, and then everything with a V in it will come up. So that is what that is. I am skeptical, but I think I see the heart of the dispute now, that Miramax thinks it owns the screenplay outside of print publications, and Tarantino only owns the right to print publication of the screenplay. And then whether the court decides in favor of Miramax or Tarantino is going to come down to whether the NFT medium falls within the print publication rights or falls within Miramax's basically all other catch-all rights. That's how important it is to have your agreements phrased correctly, and how easy it is to have something like a comma, for example. There was a case where there was overtime compensation for employees, and it was whether or not the employees had to load their own trucks or something like that, and the comma was in the wrong place, and because the comma was in the wrong place, the employees were not exempt from overtime, and the company owed, I think, millions of dollars in overtime. Whereas if the comma had been in the right place, like an Oxford comma, if it had been in the right place, then it would have excluded the time that the employees were loading and unloading their trucks, or something like that. I'll see if I can find a reference and put something on the screen here. Anyway, let me know what you think of that in the comments below. I'm a big fan of Tarantino, and I'm a little biased against major studios that just make grabs for everything they possibly can. And so I don't really see a problem with Tarantino publishing NFTs of the screenplay that I think he owns, but I see what the dispute is. I don't like it that Miramax is making this grab for this new media, and that's simply because now we have NFTs that Tarantino can't publish his screenplay. So to me, it's kind of like limiting the cool new media and art that can be published. At the same time, I guess if Miramax really did consider all new media and everything outside of print publication to be their ownership, if it was me and somebody then went and, instead of print publishing something, went and electronically published something, yeah, I guess maybe I could see a dispute there. I don't like it. Let me know what you think in the comments below. This seems at least like a real dispute. I mean, I guess they finally got around to it, but it took them a long time to make the point that he doesn't have anything but print publication rights for the screenplay. Maybe he can do it in a way that the NFT gives access to a physical copy of the screenplay, a print copy of the screenplay. So maybe he just has to modify the terms of the NFT so that he can give the digital version of what he has reserved rights to, but gives a print version for the part that he doesn't have anything but print publication rights to. Maybe that's the way around it. I don't know. Where does it say that the that print publication included electronic formats? Okay, so this is going to be one of those missing comma things. Not that a comma is missing, but you're going to have to analyze this very carefully. It says print publication, including without limitation, screenplay publication, making of books, comic books and novelization in audio and electronic formats as well as applicable. So it's going to come down to whether electronic formats applies to print publication or just applies to comic books and novelization. If comic books and novelization, comma, in audio and electronic formats as well as applicable applies just to comic books and novelization, then Tarantino loses. But if electronic formats applies to print publication, then Miramax loses. That's what I think this comes down to. Great point there. Thank you. So if it says print publication, including without limitation in audio and electronic formats, I don't know, that doesn't fit as well as if it was print publication, including screenplay publication, making of books, comic books and novelization in audio and electronic formats. You almost need like another set of parentheses that apply only to comic books and novelization. So I think that's what it is. This is one of those, how does the comma separate the language and what does it mean? So Tarantino's interpretation is that print publication includes audio and electronic formats, and Miramax's interpretation is that print publication includes comic books and novelization, which can be in audio and electronic formats, but not screenplay publication in audio and electronic formats. Wow, that is going to be super tedious for these parties to argue over. And I think you're going to actually see an expert witness, if it gets this far, an expert witness in the interpretation of language and the positioning of commas to determine what the correct interpretation of this sentence is. So yeah, this is that situation. It is a poorly worded sentence with too many commas. Not too many as in there's a misplaced comma, but just that it could be phrased completely differently with commas used differently in order to apply audio and electronic formats to comic books and novelization instead of audio and electronic formats applying to print publication, and print publication including screenplay publication. That's a really, really tedious distinction, and I don't know which way it's going to go. One of our viewers thinks that audio and electronic formats should apply to print publication. It could also be seen as applying to comic books and novelization only. Very interesting dispute. Let me know what you think in the comments below. I liked that one. That was really fun when we got to the end of it. That had like a twist ending. Had like an M. Night Shyamalan twist ending there. Thanks for watching. Special thanks to our top supporters in November: John Steele, Gavin Barnard, Eevi, Spirit Bear, Benjamin Hitov, Ugly Grill, Torpedan, ShadowTycho, Earthbound Star, PureMagma, Drew Hart, TechTechPotato, Eric Tams, and the Blood-Soaked Survivors. You can support Lawful Masses on patreon.com/ljfrench, sponsors.com/law, through YouTube membership, and through Floatplane subscriptions. Join me for our weekly production live stream on twitch.tv/lawfulmasses on Sunday mornings at 10 a.m. Eastern US time. I hope everyone has a great week. I love you all. Bye. I have a cat. I hope I didn't have a cat hair on my nose visible on screen that whole time.